Good day, Crime Talk aficionados. Welcome back. Hope you had a wonderful weekend. First, the FBI intensifies the hunt for the abducted mother of NBC anchor Savannah Guthrie. The Idaho murder victims, well, they condemn the killer Brian Kohberger following the leak of the crime scene images. South Carolina, the Supreme Court set to review Alec Murdaugh's appeal this week. The FBI investigation yields no evidence of Epstein's alleged elite sex trafficking network. A Wisconsin resident fatally shoots his neighbor and then proceeds with his tax filing before surrendering. A mother's phone discovery triggers arrest of a New Orleans biology teacher teaching biology, and an NFL rookie gets arrested. We've got This Day in Legal History, our legal quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below. Make sure you hit that little bell for notifications. And yes, you can check us out anytime on any of your favorite podcasting apps. Before we get to the docket, let me remind you, go to crimetalksearch.com. Sign up for that background subscription service today. When you do, you'll be able to do as many background searches on anyone here in the United States. The report is literally prepared while you wait. It's emailed to you, and you're going to get everything you want to know and then some about the person that you want to inquire about. You're going to find about emails, social media presence, telephone numbers. You're going to find out the cars that they've driven over the last 10 years at least. Do they have a criminal history? Married, divorced? Are they on one of those sex offender registries? Everything you want to know about somebody, you need to go to crimetalksearch.com. Find out today. You're going to be happy that you did. All right, let's go ahead and open the record for Monday, February 9th, 2026. And yes, the search intensifies. Federal authorities have escalated their involvement in the investigation into the abduction of Nancy Guthrie. Obviously, by now, most people know the 84-year-old mother of NBC Today Show anchor Savannah Guthrie amid unverified ransom demands and emerging leads in the case. Now, the disappearance, now going into its second week, has prompted multiple searches, forensic analysis, and public appeals from the family, with no suspects publicly identified as of today. So Nancy Guthrie was last observed entering the garage of her Tucson residence around 9:45 p.m. Mountain Time on January 31st, following a dinner at her daughter Annie Guthrie's nearby home. Now, concerns arose the next morning when she failed to attend a virtual church service, prompting a missing person report to be filed with the Pima County Sheriff's Department around noon on February 1st. Investigators have treated the case as a potential kidnapping, citing evidence such as blood droplets on the front porch confirmed to match her DNA, the disconnection of a doorbell camera at approximately 1:47 a.m., detected movement on security systems at about 2:12 a.m., and the cessation of data transmission from her pacemaker at 2:28 a.m. on February 1st. Additional leads include the reports of a man observed lingering in the nearby yard in early January and an unmarked white van parked in the vicinity days prior to the incident. Now, law enforcement has conducted repeated searches of Nancy Guthrie's property, including examination of a septic tank, the retrieval of a previously overlooked roof-mounted camera, and the towing of a dark SUV from the garage. Now, the consensual search at Annie Guthrie's residence yielded items such as a silver suitcase and a brown bag for further analysis. A tip also directed police to review surveillance footage from a local Circle K gas station for a vehicle of interest. There's been unverified ransom communications that have complicated the probe. Notes demanding up to $6 million in Bitcoin were dispatched to media outlets, including TMZ and the Tucson station of KOLD, with the first arriving on January 31st and a second on February 7th. Both originating from concealed IP addresses. Now, the demands included a deadline of 5 p.m. Mountain Time on February 9th, today, with the threat to the victim's safety if the demands are unmet. Now, officials have also not authenticated these messages, but are investigating their origins. In response, Savannah Guthrie, alongside her siblings, Cameron and Annie, released a video statement again on February 8th, acknowledging receipt of a message and expressing their willingness to comply with the demands to secure their mother's safe return. The family emphasized Nancy Guthrie's fragile health, including her need for daily medication, and urged for her prompt release. While the Pima County Sheriff's Department, supported by the FBI, continues to lead the effort, with the federal agency offering a $50,000 reward for information, challenges have been noted, including limited experience among some local investigators and delays in employing aerial surveillance equipment. The FBI Director, Kash Patel's arrival in Tucson on February 9th has fueled speculation of an impending breakthrough, though his visit was described as pre-scheduled. The president commented on February 7th that there were, quote, very strong clues, end quote, that had been uncovered, suggesting that potential resolution would be forthcoming soon. Now, Sheriff Chris Nanos has expressed the belief that Nancy Guthrie remains alive, underscoring the urgency of the medical needs. Now, there's also been a lot of community support and prayers, specifically from St. Andrew's Presbyterian Church, where Nancy Guthrie was an active member. As the investigation progresses, authorities have withheld details on leads to preserve the integrity of the investigation, with no press conference scheduled absent major developments. So it continues, ladies and gentlemen. Now, hopefully, if somebody knew that Nancy had these health issues, that they would plan accordingly and have her medication with her, or maybe they didn't. We don't know. It sounds like it's not exactly the most well executed police investigation. Now, I get it. Police make mistakes. They didn't know. They didn't crawl on the roof. Why would you think they'd be crawling on the roof, right? But then they've discovered from a neighbor's tip that, hey, the white roof, you may not be able to see the camera that was up there. And then they find out, there were some more cameras up there, or a camera. So, we're just going to have to wait and see where this goes. But in today's world, it would be highly unlikely that somebody, if they wanted money or Bitcoin, that it couldn't be traced. In today's world, everything is traceable. And where are they going to drop the money? You think it's just going to get dropped in a field and somehow it's not going to be watched to see if somebody comes and picks it up? Kidnapping for ransom, like I said, I've handled a couple of these over the years. They never work out. It's kind of like bank robberies. They always kind of get the guy and they never really get as much money as they think they're going to. But we'll wait and see. Obviously, we're hoping for Nancy Guthrie's safe return, but time is ticking indeed. Next on the docket, the Idaho murder victims' parents condemn Bryan Kohberger. That's right. So the family of Kaylee Gonzalez, one of the 4 University of Idaho students slain in a 2022 stabbing attack, has publicly expressed intense anger towards the convicted perpetrator, Bryan Kohberger, after the unauthorized release of nearly 3,000 crime scene photographs last month. Now, the images, initially uploaded by the Idaho State Police and promptly removed from public access, provided an unprecedented view into the Moscow, Idaho rental home where the murders occurred. Among the details captured were bloodstains on bedding, walls, furniture, and personal items like electronics, along with the indications of resistance by the victims during the assault. Now, in response to the leak, which has fueled online speculation and more conspiracy theories questioning Kohberger's guilt, the Gonzalez family has posted candid updates on social media. And on January 30th, Christy Gonzalez, Kaylee's mother, directed a pointed message at the killer, stating, quote, "F you, BK, exclamation mark, exclamation mark, exclamation mark, exclamation mark. I wish Steve would have 1 minute in that cell with him. 1 minute. That's all it would take." Well, the family reported receiving brief notification call back on about 11 o'clock in the morning on January 20th, informing them of the impending release, only to discover the photos were already accessible by the call's end. They appealed to the public for empathy, stating, quote, "Please be kind, as difficult as it is. Place yourself outside of yourself and consume the content as if it were your loved one, your daughter, your sister, your son, or brother. Murder is an entertainment, and crime scene photographs aren't content." end quote. Addressing the surge in the misinformation, including claims that an innocent individual was wrongly convicted, the family emphasized their resolve for accountability. We chose not to engage with the negativity we encounter daily. However, when we saw Kaylee's murder being defended repeatedly and the conspiracies grow, we felt compelled to share the truth. They wrote, Christie affirmed their confidence in the case's integrity, noting, quote, Kaylee is my daughter. I gave birth to her. We promised and always to protect her and keep her safe, and we will never stop doing just that, end quote. She added that the evidence suggests otherwise. They would advocate fiercely for correction. We would never, ever allow an innocent person to go to prison for taking Kaylee's life. We are not blind, we are not deaf, and we are not stupid either. As you may recall, for those that may not recall, the murder took place back on November 13th of 2022 when Koberger, then a graduate student at nearby Washington State University, stabbed Gonsalves, Madison Mogen, Zaina Kernodle, and Ethan Chapin in their off-campus residence. Now, police connected Koberger to the scene via DNA evidence from a knife sheath, leading to his arrest on December 30th of 2022. And then in July of 2025, he pled guilty under an agreement that spared him the death penalty, resulting in multiple life sentences without the possibility of parole. And no definitive motive has yet ever been established. Now, this week, Christie Gonsalves shared details of her ongoing efforts to organize her daughter's stored belongings, which have remained sealed since the tragedy. She described the process as emotionally taxing, beginning with selected items in her own bedroom to avoid the pain of Kaylee's former space. Among the possessions, she noted everyday items like whitening strips, skincare products, and electrolyte packages, underscoring the personal loss that she experienced. And she said, I just simply can't imagine throwing anything away. She says that she's keeping it all. Now, the family has expressed gratitude for the public support amid all their grief, and representatives for the families have not made any additional comment beyond that statement. Listen, I will say it again. My heart goes out to the family. I could not imagine losing a child. But I also believe one of the ways for the people to truly know what goes on in a courtroom is that we need better public access to the court. And yes, when the case is over, no matter how ugly it may be, the public has a right to know. And they have a right to know whether they are dealing with evil. And in this particular case, Brian Koberger, who went in for no apparent reason and killed 4 people with a knife and stabbing them, 20 to 40 times each. That's evil, ladies and gentlemen. That is pure after deliberation. And yes, the people should be able to see it, and it still can be done. It can be redacted. But the reality of it is, I think, people should have a right to see it. And here's the thing, if you don't want to see it, you don't have to. Autopsy photos, crime scene photos, they're not entertainment, but they're the truth. And sometimes the world needs the truth to see it, no matter how ugly it may be. Next, the South Carolina Supreme Court is going to hear argument in regards to the case of Alec Murdaugh. That's right. The South Carolina Supreme Court is scheduled to consider an appeal from the convicted murderer, Alec Murdaugh, and former attorney, seeking a retrial for the 2021 killing of his wife, Maggie, and son, Paul. Now, Alec Murdaugh, who has consistently asserted his innocence, was found guilty by a jury and received a life sentence without the possibility of parole. Now, the appeal, which was submitted back in December of 2024, contends that certain evidence was inappropriately allowed during the original proceedings and alleges misconduct by the court clerk in influencing the jury's decision. Now, a significant portion of the 132-page brief challenges the evidentiary foundation of the conviction, noting a scarcity of the direct physical links to Murdaugh. It criticizes the inclusion of testimony from an investigator who demonstrated phone damage by handling an iPhone in his office, deemed it unreliable. Additionally, the appeal highlights the omission of text exchanges between Murdaugh and an individual identified as his, quote, drug supplier, Eddie Smith, around the time of the murders, which were not incorporated into the prosecution's chronological account. Now, the remainder of the filing centers on the allegations of Becky Hill, the former Colleton County clerk, and Hill admitted guilt to a charge of obstruction of justice and perjury related to sharing sealed materials with a journalist and providing false statements about the incidents. Murdaugh's legal team accused her of making prejudicial remarks to jurors to sway them towards a guilty verdict, potentially motivated by her book deal that she was working on. Now, Hill has refuted claims of any improper jury interactions, but, she did plead guilty, didn't she now, ladies and gentlemen? And even though the judge found her not to be credible when they brought the senior judge in to hold the whole hearing on that and interview the jurors, basically said, Miss Hill was, let's just say, speaking with a forked tongue. And, but they said basically, we're not going to allow, it wouldn't have changed the result. Well, we'll see. I still personally think all the stuff about all the thefts, it should have been touched on briefly, but they went into complete overkill. I think it was violation of the 404B evidence rule, and that in and of itself should warrant a reversal and a new trial. Now, don't get me wrong. Like I said, I think he did it, but we got to give somebody a fair trial before we convict him, and I don't think that trial was fair. But that's just my humble opinion. We'll see if the South Carolina Supreme Court agrees with me at all. Next on the docket, let's talk about kind of what we've seen from the review of the Epstein files to date. All right. So despite extensive scrutiny of Jeffrey Epstein's financial transactions, communications, and personal properties, federal investigators uncovered substantial proof of his sexual exploitation of minors, but little to support allegations he orchestrated a sex trafficking operation catering to influential figures, according to the analysis of recently disclosed Justice Department documents. So internal memos and investigative summaries reveal that materials confiscated from Epstein's residence in New York, Florida, and the U.S. Virgin Islands, including videos and photographs, failed to document any instances of victim abuse or involvement by third parties in his offenses. So a 2025 prosecutorial note emphasized that these items did not portray exploitative acts or linked others to criminal conduct. Now, further examination of Epstein's banking activities, which included disbursements to organizations associated with prominent individuals in education, business, and international affairs, similarly yielded no ties to unlawful behavior, as detailed in the 2019 internal report. Now, although one prominent accuser publicly alleged that Epstein facilitated her exploitation by affluent associates, federal agents were unable to substantiate this claim and then had no comparable accounts emerge from other victims, according to these records. Now, in July, a summary email investigators noted that while a small number of approximately 4 or 5 of Epstein's accusers reported abuse by additional individuals, insufficient evidence existed to pursue federal charges, leading to referral to state authorities. Now, these findings emerged from the millions of pages of previously sealed documents released by the Justice Department pursuant to the Epstein Files Transparency Act. Now, media outlets, including the Associated Press, continue to examine these documents, which may yet reveal overlooked details. And the materials encompassing law enforcement reports, interview transcripts, and correspondence among prosecutors offer the most comprehensive insight to date into the probe and to the rationale for concluding it without further indictments of third parties. Now, background of Epstein's case, right? So what do we know? Now, the investigation originated in 2005, following a report from the Guardian of a 14-year-old girl who was allegedly molested at Epstein's Palm Beach estate. Police subsequently identified at least 35 minors with analogous experiences involving payments for erotic massages. Initially, federal charges were prepared against Epstein and certain aides, but a plea agreement negotiated by the then U.S. Attorney Alexander Acosta in Miami allowed Epstein to admit guilt to state-level prostitution solicitation involving a minor. He served a reduced sentence and was released by 2009. Then, back in 2018, there's another kind of renewed attention, and it's spurred by the investigative journalist from the Miami Herald that prompted New York prosecutors to reopen the case. Epstein's arrest occurred back in July of 2019, followed by his suicide in custody a month later. And then in 2020, charges were filed against Ghislaine Maxwell, Epstein's close associate, for recruiting victims and participation in the abuse. Now, she was convicted in 2021 and is currently serving a 20-year prison sentence. So what was the big deal in verifying these big allegations? So prosecutors and the FBI personnel meticulously followed leads on potential accomplices, including anonymous tips received via hotlines. Even improbable assertions were vetted. Interviews with Virginia Roberts Jeffrey, who actually filed the suit and spoke publicly about being directed by Epstein to engage with sex with high-profile men such as former British Royal Prince Andrew of Windsor, confirmed her own victimization, but raised doubts about other elements. Now, 2 additional victims Jeffrey referenced denied similar experiences, and per her 2019 memo, which also highlighted inconsistencies in her narratives, included embellished media portrayals and a partially fabricated autobiography. Now, efforts to interview, for example, the Prince Andrew, were unsuccessful, though Jeffrey resolved a lawsuit against him alleging misconduct. And in her posthumous memoir, Jeffrey maintained the veracity of her trafficking claims and suggested prosecutors excluded her from Maxwell's trial to avoid complicating the proceedings. Ultimately, the absence of incriminating media and financial links seized digital and physical media contained nude imagery of females, some potentially underage, and a minor amount of commercially sourced child exploitation material. However, no content depicted abuse of Epstein's victims' involvement of males or implications of others beyond Epstein and Maxwell, as affirmed by the communications between the United States Attorney's Office, Maureen Comey. That's right, Jim Comey's daughter, who prosecuted Ghislaine Maxwell. Then we got bank records that showed payments to over 24 women identified as models, but no indication of prostitution services extended to third parties. And then what are you going to decisions against charging, right? So you have to look at everything that was given to the prosecution, one of Epstein's aides, but it was declined upon determining she was also a victim of his coercion. You got ties to French agent Jean-Luc Brunel, accused separately of assaults, were reviewed. Brunel died by suicide while detained in France. Another romantic partner of Epstein's involved in acts with victims during her late teens was interviewed, but not charged due to evidentiary shortfalls. Subpoenas were prepared for Epstein's pilots and business affiliates. Les Wexner, a retail executive, that's right, the guy that started Victoria's Secrets, and Wexner's representatives denied knowledge of Epstein's crimes, noting a 2007 severance over financial improprieties. Investigators found minimal evidence against him and cleared him of any target status. And then there's allegations against investor Leon Black stemming from a massage incident were probed by local prosecutors but resulted in no charges. Black's counsel denied wrongdoing and affirmed his unawareness of Epstein's activities. And this is all related to civil suits that have largely been resolved. Then what about this client list, right? Claims by former Attorney General Pam Bondi in 2025, interviews regarding the undisclosed client list, and vast video collections were contradicted by FBI's assessments. Internal correspondence from late 2024 and early 2025 confirmed no such list was discovered despite persistent media references. And then you got survivors of Epstein's abuse have expressed dissatisfaction with document redactions, advocating for total transparency. Now, the Justice Department's ongoing release, exceeding 3 million pages, aims to obviously try to balance the public interest while balancing investigative integrity. So, we got a complex situation here, a lot of high-profile investigations where public speculation may outpace verifiable evidence. And additional files become available. Who knows? Maybe something will lead from it. But as of right now, like I say all the time, it doesn't matter what you think or believe. It only matters what you can prove beyond a reasonable doubt unanimously to a jury. But in this particular case, don't get me wrong. Listen, I wanted everything released. I still think everything should be released. Obviously, they don't need to release, child exploitative material, which is, formerly known as inappropriate child content, right? We'll just leave it at that. That should not be released for obvious reasons. Everything else should be. I understand trying to release and redact the names, but hey, they've all been settled in civil suits. Let the truth be told. And if people settled, if there's non-disclosure agreements, those should be released as well. Now, do people settle lawsuits all the time that they think they're not responsible for because, frankly, it's easier to write a check than go on litigation for years and years? Absolutely. Doesn't mean they're always guilty. No, sometimes there's a nuisance factor to it. Like I said, nobody wanted to see a big list, right? As it relates to Epstein and Maxwell, that they had this, the little black book existed and they had the list of all their clients and everything they did. Now, don't get me wrong. Am I naive enough to think that all these guys just happened to go to Epstein's Island where, all the girls were going to be under 25 and, they all sat around and discussed English literature? No, I'm not. Let's get for real. But it's another thing to be able to prove it. So I get it. And remember when I've told you this, remember one of the attorneys that represented Ghislaine Maxwell was here from Colorado. I know this particular attorney. And I was like, I was like, got to tell me, they're a little black book. She's like, I can't really talk about it, but, basically, like, there's nothing there. That was basically the gist. Like, people are going to be disappointed because there's nothing there. Not what everybody was thinking there was. And I think that's ultimately what's turning out to be in this stuff. A lot of speculation, a lot of people saying, oh, somebody did something, but they have no real proof. Okay. I could provide anonymous tips saying everybody, that watches this video did terrible things to minors. Are the police going to look into it? Maybe. Maybe they say, oh, this guy's just a crackpot. Or maybe they go look into it and they say, God, this guy doesn't know what the hell he's doing. He's just making false reports. And if you look at some of those documents, and I've looked a lot of those documents in there are people just calling up and complaining about people and saying that they had involvement with this case when they didn't. And there was nothing to back it up. We'll see where it heads out, ladies and gentlemen. Obviously, there's going to be more to come. I mean, if people have committed crimes against children, they need to be held accountable. That's it. But remember, you got to be able to prove it as well. Next on the docket, man shoots his neighbor and then, before he surrenders, figures he better do his taxes. So in a bit of a disturbing incident in Milwaukee, Wisconsin, a 31-year-old man has been charged with first-degree intentional homicide after allegedly shooting his 50-year-old neighbor in the head, apparently driven by some unfounded belief of terrorism and militia involvement. Now, the suspect, Dominic Nosek, reportedly returned to his apartment to complete his tax returns following the act before voluntarily reporting the crime to police. So according to official police records from the Milwaukee County Sheriff's Office, Nosek entered a federal building housing a Department of Homeland Security office on the morning of February 5th of 2026. He approached a security officer and confessed to having, quote, killed a militia, end quote, by shooting the individual in the head. The guard, after screening Nosek through a metal detector and seating him, promptly contacted the police. Now, Nosek informed the security personnel that he had left an AK-47 rifle, the weapon used in the shooting, at his residence on North Astor Street. He further stated that after the incident, he went back home to handle his taxes. A second security officer corroborated the account, noting that Nosek described the victim as a terrorist and relating his admission of the killing. Well, needless to say, police responded to the apartment building where they discovered the body of Angelo Nelson in the hallway, deceased from a single gunshot wound to the head. During subsequent questioning, after being read his rights, Nosek explained his actions, citing ongoing disturbances from neighbors whom he perceived as harassing him. He disclosed a personal history of psychosis and depression, claiming his neighbors were part of a militia engaged in blackmail against him. Nosek alleged that Nelson's presence in the hallway appeared provocative, as if the victim was waiting for him. Armed with the rifle, Nosek stated he fired to prevent any potential threat, affirming his intent to kill because he believed the neighbors were militia members. He confirmed that Nelson was unarmed and that no verbal altercation preceded the shooting. Now, in addition to the homicide charge, Nosek faces a bail jumping accusation related to a prior offense. And following his initial court appearance on February 8th, the judge set his bail at $251,000 cash only. He remains detained with no further hearing date announced as of yet. Investigation is going to continue. Get the competency doctor over to see Mr. Nosek as quickly as possible. The paranoia, along with the depression, let's get this guy shrunk as quickly as possible. Next on the docket, mom going through her kid's phone. Well, it reveals some disturbing information. So a 29-year-old biology teacher at the elite academy of the Sacred Heart is facing criminal charges after police say she carried on a month-long relationship, a sexual relationship with a student, a case that only came to light when the girl's mother searched her daughter's phone and uncovered explicit text messages, nude photos, and videos. So Teddy Page turned herself into the New Orleans Police Department last Thursday after school officials reported the allegations. She was booked on one count of prohibited sexual conduct between an educator and a student, a misdemeanor under Louisiana law. Now, according to the police records, the alleged relationship began last August, shortly after Page was hired to teach at the prestigious all-girl Catholic school. The student was 17 years old at the start of the relationship and later turned 18. The pair allegedly had sexual intercourse multiple times, including at Page's residence and inside a vehicle parked behind a local restaurant. Now, the investigation was launched after the victim's mother confronted the principal at the Sacred Heart School with the disturbing evidence found on her daughter's phone. Needless to say, school administrators do what they do. They acted quickly, terminating Page's employment on the spot, escorting her off campus, and notifying the police. In a statement, the academy gave, of course, the statement of, quote, "When our school became aware of recent concerns about one of our employees, we took the matter very seriously and immediately followed our safety protocols," end quote. Well, needless to say, Miss Page appeared in court last Friday, where a judge set her bond at $15,000. The judge also denied the protective order against Page because the student is now 18 and the relationship was described as, quote, consensual. However, the court did issue a stay-away order protecting the student's mother. Needless to say, apparently this has been quite shocking to this little tight-knit school there in New Orleans and raises questions about boundaries with educators and their students these days, does it not? Anyway, if anyone has any additional information, contact the New Orleans Police Department. But don't you love how the schools always say, as soon as we became aware of this, right? Never goes into negligent hiring, like, you should have gone to crimetalksearch.com, done a background search on her, right? Maybe realizing or noticing that somebody's spending a little too much time with that particular student, perhaps. Really? I bet you there's going to be a slew of people that said, oh, yeah, we saw that. Yeah. They always do. But it's always about the money at the end, ladies and gentlemen. And what they're going to do is they're going to say, oh, we didn't know. Don't sue us. That's why they always issue those statements. As soon as we became aware of this. Next, an NFL rookie gets arrested for crashing his Lamborghini into his girlfriend's car. It happens. So the Atlantic Falcons linebacker, James Pearce Jr., a prominent NFL rookie, faces allegations of intentionally colliding his Lamborghini with the car of his former girlfriend, WNBA player Ricky Jackson, prior to his arrest on charges including aggravated battery with a deadly weapon, according to the police report. The 22-year-old athlete was released on a $20,000 bond following his detention on Saturday in Doral, Florida. The incident reportedly stemmed from a domestic altercation involving Jackson, a 24-year-old forward for the Los Angeles Sparks. Police asserts that the pair had ended their 3-year relationship recently, after which Jackson blocked Pearce's phone number. He allegedly circumvented this by sending unsolicited messages from an alternate device. And as detailed in the police report acquired by ESPN, Jackson observed Pearce's Lamborghini SUV trailing her about 9:25 a.m. on Saturday while entering her neighborhood. At the traffic light, Pearce is said to have exited his SUV and attempted to access her driver's side door. Jackson reportedly accelerated away, heading forward to the police headquarters while contacting, the police on the phone. Well, further accounts from responding officers indicate that Pearce blocked Jackson's path to the police station, and as she reversed to evade him, he purportedly drove head into her car. Upon arrival at the scene, one officer drew a firearm and instructed Pearce to lie on the ground, but he re-entered his Lamborghini instead, apparently trying to get shot. Anyway, efforts to remove him from the vehicle were unsuccessful on 2 occasions, leading Pearce to drive off and reportedly strike an officer's knee in the process. You mean to tell me somebody struck an officer with a car and he didn't get shot? Anyway, subsequent pursuit ensued, culminating in Pearce crashing near Northwest 102nd Path and 65th Lane. He attempted to flee on foot, but was apprehended after a brief resistance, during which he was tensed his arms and tried to impede officers. Now, video circulating on social media shows the 6'5", 243-pound player being subdued by 6 officers. Now, a judicial order now prohibits Pearce from contacting Jackson, which would have been the easy way to do it. Anyway, obviously this may have some impact on his professional trajectory following a notable rookie season that placed him 3rd in Defensive Rookie of the Year voting just this past year. Jackson currently competes for the Breeze in the Unrivaled League, participating in a game shortly before the event. Apparently, the couple appeared together publicly, including the NFL draft the prior year. And in response, the Atlantic Falcons say, quote, "We are aware of the incident involving James Pearce Jr. in Miami. We are in the process of gathering more information and will not have any further comment on any open legal matter at this time. And of course, we'll get rid of him, assuming he becomes too much of a liability or can't play. But if he's a really good player, we'll keep him," right? Now, listen, I get it. Young love, he wanted to keep the relationship going. She didn't want to talk with him. Hate to break it to you guys. And this goes for women too. When the girl or the guy say, we don't want to talk anymore, that means don't want to talk. If she blocks you from your phone, you can't burn up another phone trying to contact her on the phone. That gets a little weird and creepy. Certainly minimum harassment, borderline stalking. And then you start ramming cars, it gets tricky, right? Now we're talking about felonies. Is she really worth it? No. And if she's going to send you to jail once, she'll do it again. That goes for guys as well, for women. Okay? If somebody goes to jail in a DV case at least once, guess what? It's going to happen again. It always does, because the other side always knows that little weight that they have that they can swing around and threaten people with. So feel sorry for this young man, but man, let it go. Let it go. Next on the docket, how about this day in legal history? February 9th. Let's jump back to 1825. The U.S. House of Representatives elected John Quincy Adams as the 6th president of the United States in a contingent election, as no candidate had secured a majority of the electoral votes in the 1824 presidential election. This process, mandated by the 12th Amendment to the Constitution, resolved the contest among Adams, Andrews, Jackson, William H. Crawford, and Henry Clay, though it sparked allegations of a corrupt bargain due to Clay's subsequent appointment as the Secretary of State. And then in 1909, Congress passed the Opium Exclusion Act on this date, the first federal legislation in the United States to prohibit the importation and use of opium for non-medical purposes. The statute marked a foundational step in federal narcotics regulation and laid the groundwork for the subsequent drug control policies. And on this date, in 2017, a 3-judge panel of the U.S. Court of Appeals for the Ninth Circuit unanimously upheld a temporary restraining order against then-President Trump and his executive order 13769, which restricted travel from 7 predominantly Muslim countries. This ruling, in the case of State of Washington v. Trump, affirmed the district court's finding that the order likely violated constitutional protection against religious discrimination. Little side note, basically, when Biden came into office, he repealed that executive order, so litigation stopped. Same executive order with a little bit different twist came on and said, hey, we're not going to restrict you just because you're from a Muslim country. We're going to have everybody declared to be terrorists or be part of a terrorist organization or various other reasons not to let people in. But subsequent Supreme Court cases have affirmed that the president can do that in his broad plenary powers when it comes to immigration. Next, how about a legal quote of the day? How about a legal pronouncement regarding a defendant's right to remain silent that originated from the United States Supreme Court decision in Murdaugh v. Arizona? Now, in that majority opinion, Chief Justice Earl Warren stated, quote, he, referring to the defendant, must be warned prior to any questioning that he has the right to remain silent, that anything he says can be used against him in a court of law, and that he has the right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to any questioning if he so desires. Now, this ruling establishes the procedural safeguards now commonly known as Miranda warnings, which protect against self-incrimination under the Fifth Amendment to the United States Constitution during custodial interrogations. Remember, ladies and gentlemen, everybody says they arrested me. They violated my rights. They didn't read my Miranda rights. Nope. You have to be in custody and they have to be questioning you. And it never ceases to amaze me, ladies and gentlemen. The United States Supreme Court creates this Miranda advisement, tells the police to warn the person that anything you say can and will be used against you. Get an attorney. In fact, we'll even get you a free attorney. And so many defendants start talking. Well, I just want to figure out what was going on. No. If they're reading you your Miranda rights, you are not just a mere witness. You're a suspect. They think they're about to elicit incriminating statements against you. That's why you got to go lawyer, lawyer, lawyer. It's that simple, ladies and gentlemen.
All right, lawyer, lawyer, lawyer.
Next, and finally for the day, our dumb criminal of the day. In a tale that could only unfold in the Sunshine State, a 51-year-old resident has found himself entangled in a series of scandalous escapades involving household appliances and public nudity, ultimately culminating in a felony charge that underscores the perils of unchecked impulses. Please meet Kevin Westerhold, a condominium owner at Windsor Hill Resort near Disney World. He was apprehended last month after reports of his unconventional outdoor activities. Court records reveal that Westerhold, who acquired a 3-bedroom unit with his spouse for a mere $187,500 in 2019, and now leases it out, had been observed by neighbors on several occasions strolling through the property in various states of undress, ranging from complete nudity to minimal attire such as socks or a tank top. Now, 2 vigilant neighbors provided law enforcement with video evidence captured by the doorbell cameras showing Westerhold in a communal corridor with no clothing. In one particularly explicit recording, police allege he was engaging in self-stimulation. The saga escalated when additional eyewitnesses at a nearby 4-bedroom residence owned by a female family member encountered Westerhold in a compromising position with a vacuum cleaner. One observer, staying in a short-term rental, glanced out her window to witness the man unclothed below the waist, positioning at the front entrance of the opposite home. Now, according to investigative reports, he used the vacuum's handled attachment for intimate purposes, moving from the doorway to the driveway in full view. A second witness, alerted the first, corroborated the scene, noting how Westerhold alternated between inserting and applying suction on sensitive areas, displaying evident signs of arousal. The pair described the actions as unmistakably driven by personal gratification, prompting them to notify the police. Westerhold now faces felony charges stemming from these indecent exposure episodes at the gated community. A stark reminder that even in paradise, certain boundaries remain firmly in place. Now, as this case proceeds, it serves as a curious footnote in Florida's anthology of eccentric legal entanglements. Ladies and gentlemen, you can't make this stuff up, but it happens every day in a community near you, not just in Florida. Okay, it just seems like we get a lot of cases from Florida for our dumb criminal. I don't know why, but sir, you are our dumb criminal of the day. Congratulations. And if anyone wants to get him, I don't know, maybe a good old shop vac for Christmas next year, maybe we could all chip in and get him something. What do you think? All right, that's all we have for today, ladies and gentlemen. Thanks for watching. Hope you enjoyed the show. We'll see you tomorrow. And remember, the Constitution matters.